Good evening, everyone. Thank you for coming. My name is Tom Perry. I'm the assistant principal here at Friends. While Bo is out on sabbatical, I'm also the acting principal, so I'm here. I'm going to introduce Charlie tonight, but I want to say a few things about him first. At first, I was going to refer to him as a guest speaker, and I realized Charlie's been here 35 years. He's not a guest. But in those 35 years, he's been chair of the history department 2 times. He's been co-chair of the Friends Seminary Teachers Association 2 times. He's been on the Friends Seminary School Committee. He initiated several programs. One was the International Relations course with the Model UN program, and he was the first person to teach Facing History and Ourselves here at Friends. And he initiated the law course, including the mock trial program. And that course is actually one of the most popular electives we have here for seniors and juniors also. In fact, as Charlie retires this year, he has agreed to come back to teach that class next year. So he's not really leaving us at the end of the year. But it is one of our most popular classes. And tonight he's going to talk about 2 different approaches to constitutional interpretation. We've all heard about these in the news, and we're all probably pretty familiar with them. In fact, we probably all adopt one of our own. But the 2 are the living construction and the strict construction, or the living constitution, excuse me, and the strict constructionist approaches to constitutional interpretation. And he's going to lead some of his students in a demonstration of the mock trial. So please welcome Charlie Blank.
First, thanks to all of you for coming, and thanks to Tom for the introduction. Maybe you should pass out the microphones. Do they need any instruction on how to use it? Okay? Okay. So I want to begin by thanking the Friends Seminary administration for giving me this honor. This talk will be about my law course. I've taught it for over 30 years. It began as a 2-day, sort of daunting. It began as a 2-day per week seminar for a semester only, and now it's a year-long full course. The course now has 3 parts. In the fall, we do constitutional law cases, civil liberties and civil rights cases, equal protection of the law cases, liberty privacy cases, which I'll be talking about mostly tonight, and freedom of speech, press, and religion cases. Then, in the winter, we begin preparation for the mock trial competition, the New York State Bar Association's mock trial. And then in the spring, we return to constitutional law with a focus on defendants' rights. My plan for the talk is to give you a sampling of what goes on in both the constitutional law part of the course and the mock trial parts of the course. I'll be assisted by some students who are currently in the course who will help me in the discussion of the cases and present part of this year's mock trial. In the interest of full disclosure, I'm not a lawyer, but I studied constitutional law in college and graduate school, and thanks to the help of Professor Sylvia Law, a parent of a Friends alum, I spent my sabbatical sitting in on classes at NYU Law School. I sat in the back of a large lecture class in an auditorium in a constitutional law lecture class, and only spoke when they were discussing an educational equity case where I thought my experience as a Friends teacher would be relevant. But one day, when the professor was discussing censorship cases, he asked if anyone had seen the film Carnal Knowledge. Since the film was from the early 70s, I was the only one who raised a hand. The film was directed by Mike Nichols, for those of you who don't know, and featured Jack Nicholson and Art Garfunkel. So it wasn't as pornographic as it sounded. But I thought all the students were looking around trying to figure out who the dirty old man was. At different times, I co-taught the law course with Mitchell Bright and Craig Sellers, lawyers who worked at Friends in different capacities. For the mock trial, I've been helped by several lawyers who've given generously of their time. Carolyn Stevens, Mitchell Bright, Steve Bennett, a Friends parent, Everett Ware, a Friends alum, Elizabeth Schrero, another Friends parent. All of these lawyers enormously enriched the learning that took place in the classes, so I want to thank them for their work. I'm also grateful to Friends and to my department for supporting the course, and of course I'm grateful for the energy and commitment of the many Friends students, such as these, who've taken the course and participated in the mock trials. I'll begin with the constitutional law part of the course. I tell students that the study of constitutional law combines history, political science, biography, ethics, and social philosophy. So in this course, students not only learn about the Supreme Court, but also learn to clarify their own values about some controversial issues in our society by considering opinions on multiple sides of these issues. The tests in the course, as they know, are take-home open book tests. The students write their own opinions on the controversial cases, explaining which justices' opinions they agree with, which they disagree with, and why. Some people have been surprised that high school students can deal with such complex material, but I found that almost all of them rise to the challenge. One of the central questions that permeates the civil rights and civil liberties part of the course is when and under what circumstances should 9 appointed members of the Supreme Court have the power to declare laws passed by the democratically elected representatives of the people to be unconstitutional. In other words, how should the justices exercise the power of judicial review responsibly? This is an issue you've heard discussed recently in relation to the healthcare debate before the Supreme Court. So I'm now going to walk you through a very condensed version of how the course helps students think about this question. We'll begin with Lochner v. New York, a 1905 Supreme Court case. This case focused on a labor reform law passed in New York State that limited the hours of bakery workers to 10 hours a day, 6 days a week. Not much of a limit. The law was challenged as being a violation of the 14th Amendment's Due Process Clause. As you may remember, the 14th Amendment says a state cannot deprive any person of life, liberty, or property without due process of law. In Lochner, the majority of justices on the Supreme Court ruled that the law that set a limit on bakery workers' hours was unconstitutional because it violated the right to make a contract of employers and employees, and that liberty of contract was part of the liberty of the 14th Amendment. The dissenters said that the word liberty was being perverted by the majority of the court's justices, who were writing their own socioeconomic opinions and values into the Constitution rather than respecting the rights of the majority of the voters who had elected the legislators who passed the law. In essence, the dissenters were objecting to what they saw as an overly broad interpretation of the 14th Amendment that advanced a politically conservative agenda. This principle of liberty of contract, which of course is not explicitly stated in the Constitution, was used to strike down many state and national labor reform laws through the early stages of the New Deal. Eventually, President Franklin Roosevelt was able to make several appointments to the court when several justices retired or died, and the court shifted dramatically against the kinds of decisions that the justices, whom Roosevelt had called the 9 old men, were making on social and economic legislation. At that point, there was a general agreement that the court had overstepped its proper limitations in declaring much of the early New Deal legislation to be unconstitutional. There was also a general agreement that the court should defer to the elected branches in cases involving broad social and economic legislation. But when new issues arose, the justices of the Roosevelt Court divided over the proper role of the court. Some justices applied what they saw as the lessons of Lochner and the New Deal Court to almost all cases. Other justices distinguished between different types of cases. Justice Felix Frankfurter argued that the court should avoid the abuse of power displayed in Lochner and the New Deal cases by deferring to the elected branches and not writing its own opinions into the Constitution. In other words, a doctrine of judicial deference. Frankfurter applied this doctrine even to free speech and religion cases like the compulsory flag salute cases, where he voted in favor of the school board's power to expel students who refused to salute the flag on religious grounds. Justice Hugo Black sought to avoid what he saw as the problem of Lochner by relying on a strict literal interpretation of the Constitution. He even held that wiretapping did not require a search warrant because it did not involve searching, quote, persons, houses, papers, or effects, the literal words of the Fourth Amendment. Wiretaps, he said, only involved intangible conversations. But in contrast to these two justices, Chief Justice Harlan Fiske Stone had a more complex analysis. Stone argued that the court should defer to the legislatures in cases involving what he called ordinary commercial transactions. But he believed that the court should exercise stricter scrutiny in three kinds of cases. First, cases involving specific prohibitions of the Constitution, such as those in the Bill of Rights. Second, cases involving the rights of discrete and insular minorities, as he called them, whose rights the majority did not protect. And third, cases in which the legislation restricted the political process. Throughout the second half of the 20th century and into the 21st, the majority of justices have applied Chief Justice Stone's principles to their decisions in some of the freedom of speech, press, and religion cases, and in some equal protection of the laws cases involving race and gender discrimination. In the liberty privacy cases we'll look at next, the majority of the court argues that even though the right involved is not explicitly listed in the Bill of Rights, there is a fundamental liberty at stake which the legislature cannot violate, the kind of fundamental liberty that Stone was talking about. Meanwhile, the dissenters argue that the liberty being cited is not one that is stated in the Constitution, nor long recognized by the American people. Instead, they say, the court is following the discredited Lochner precedent and writing its own values into the Constitution and overriding the will of the voters. We'll take a look at some of these liberty privacy cases involving contraception, abortion, and gay rights. When I discuss these cases, I'm going to do something I do in class. I'm going to have some current students in the law class read excerpts from these opinions aloud. The reason I do this is not just to have the students focus on key passages, but to help them experience some of the excitement and passion of the intellectual clashes. We'll begin with Griswold versus Connecticut. This was a 1965 case that challenged the constitutionality of a state law that prohibited even married couples from using contraception. That's right, I did say 1965. After I wrote that, I realized that could either be because it was so late that they were fighting over that battle, or it was so long ago that it looked like that battle got resolved and now it's back again. In the majority opinion for this case, Justice Douglas acknowledged that the right to use contraception, or more broadly, a right to privacy, is not explicitly mentioned in the Bill of Rights. But he argued that taken together, a long list of constitutional amendments imply zones of privacy protected from government intrusion. He found these implications for zones of privacy in, and here comes the long list, the First Amendment's guarantee of freedom of speech, religion, and assembly. In other words, rights of conscience and of association. In the Third Amendment's prohibition against the quartering of troops in private homes. The Fourth Amendment's guarantee of the right of the people to be secure in their homes against unreasonable searches and seizures. The Fifth Amendment's protection against self-incrimination. And finally, the Ninth Amendment, which says that the people retain rights not specified in the Constitution. Douglas argued that collectively these amendments created a zone of privacy. He went on to differentiate the Griswold case from Lochner, the bakery workers case, by arguing that the right involved in the Griswold case, unlike the right involved in the Lochner case, was a fundamental right. Patrick Smith will read an excerpt from Douglas's opinion of the court.
We do not need a super legislature to determine the wisdom, need, and propriety of laws that touch economic problems, business affairs, or social conditions. This law, however, operates directly on an intimate relationship of husband and wife and their physician's role in one aspect of that relationship. Would we allow the police to search the sacred precincts of marital bedrooms for telltale signs of the use of contraceptives? The very idea is repulsive to the notions of privacy surrounding the marriage relationship. We deal with a right of privacy older than the Bill of Rights.
Ken Armstrong will read from Justice Black's dissent.
I like my privacy as well as the next one, but I am nevertheless compelled to admit that government has the right to invade it unless prohibited by some specific constitutional provision. I do not believe that we are granted power by the Due Process Clause or any other constitutional provision or provisions to measure constitutionality by our belief that legislation is arbitrary, capricious, or unreasonable, or accomplishes no justifiable purpose, or is offensive to our notions of civilized standards of conduct. Such an appraisal of the wisdom of legislation is an attribute of the power to make laws, not of the power to interpret them. If any broad, unlimited power to hold laws unconstitutional because they offend what this court conceives to be the collective conscience of the people is vested in this court by the 14th Amendment or any other amendment of the Constitution, it was not given by the framers, but rather bestowed on the court by the court. The adoption of such a loose, flexible, uncontrolled standard for holding laws unconstitutional will amount to a great constitutional shift of power to the courts. The Due Process Clause, with an arbitrary and capricious or shocking to the conscience formula, was liberally used by this court to strike down economic legislation in the early decades of this century, threatening, many people thought, the tranquility and stability of the nation.
These lines of argument continued in 1973 in the court's decision in Roe v. Wade. As many of you know, in Roe, the court, by a 7-2 majority, struck down a Texas law that made abortion a crime unless it was necessary to save the life of the woman. Ken will read an excerpt from Justice Blackmun's opinion of the court.
The Constitution does not explicitly mention any right of privacy. In a line of decisions, however, the court has recognized that a right of personal privacy or a guarantee of certain areas of zones of privacy does exist under the Constitution. These decisions make it clear that only personal rights that can be deemed fundamental or implicit in the concept of ordered liberty are included in this guarantee of personal privacy. They also make it clear that the right has some extension to activities relating to marriage, procreation, contraception, family relationships, and child rearing and education. This right of privacy, whether it be founded in the 14th Amendment's concept of personal liberty and restrictions on state action, as we feel it is, or as the district court determined in the 9th Amendment's reservation of rights to the people, is broad enough to encompass a woman's decision whether or not to terminate her pregnancy.
Maggie Beth Gibson will read an excerpt from Justice White's dissent.
I find nothing in the language or history of the Constitution to support the court's judgment. The court simply fashions and announces a new constitutional right for pregnant mothers and, with scarcely any reason or authority for its actions, invests that right with sufficient substance to override most existing state abortion laws. As an exercise of raw judicial power, the court perhaps has the authority to do what it does today, but in my view, its judgment is an improvident and extravagant exercise of power of judicial review that the Constitution extends to the court.
And Maggie's going to read the other major dissent from Justice Rehnquist.
The fact that a majority of the states reflecting, after all, the majority sentiment in those states have had restrictions on abortion for at least a century is a strong indication, it seems to me, that the asserted right to an abortion is not so rooted in the traditions and conscience of our people to be ranked as fundamental. The only conclusion possible from this history is that the drafters did not intend to have the 14th Amendment withdraw from the states the power to legislate with respect to this matter.
Republican presidents committed themselves to appointing justices who would overturn Roe v. Wade. But in the 1992 case, Planned Parenthood v. Casey, 3 justices, O'Connor and Kennedy, who were appointed by President Reagan, and Souter, appointed by President George H.W. Bush, wrote a joint opinion reaffirming the central holding, as they called it, of Roe, although allowing state restrictions on the right to choose to have an abortion that are not their term, an undue burden. Alma Torres will read an excerpt from the joint opinion.
It is a promise of the Constitution that there is a realm of personal liberty which the government may not enter. Our law affords constitutional protection to personal decisions related to marriage, procreation, contraception, family relationships, child rearing, and education. These matters, involving the most intimate and personal choices a person may make in a lifetime, choices central to personal dignity and autonomy, are central to the liberty protected by the 14th Amendment. The mother who carries a child to full term is subject to anxieties, to physical constraints, to pain that only she must bear. Her suffering is too intimate and personal for the state to insist, without more, upon its own vision of the woman's role, however dominant that vision has been in the course of our history and culture. The destiny of the woman must be shaped to a large extent on her own conception of spiritual imperatives and her place in society.
Sonia Grozak will read an excerpt from Justice Scalia's dissent.
The permissibility of abortion and the limitations upon it are to be resolved, like most important questions in our democracy, by citizens trying to persuade one another and then voting. The issue in this case is not whether the power of a woman to abort her unborn child is a liberty in the absolute sense, or even if it is a liberty of great importance to many women. Of course it is both. The issue is whether it is a liberty protected by the Constitution. I am not sure it is. I am sure it is not. I reached that conclusion because of two simple facts. One, the Constitution says absolutely nothing about it, and two, the long-standing traditions of American society have permitted it to be legally prescribed. The imperial judiciary lives. We should get out of this area where we have no right to be and where we do neither ourselves nor our country any good by remaining.
Finally, in 2003, in the Lawrence v. Texas case, the court ruled that a Texas law that banned homosexual sodomy was unconstitutional. The court was reversing a precedent from a similar 1986 case, Bowers v. Hardwick. Susie Church will read an excerpt from Justice Kennedy's opinion.
The petitioners are entitled to respect for their private lives. The state cannot demean their existence by making their private sexual conduct a crime. Their right to liberty under the Due Process Clause gives them the full right to engage in their conduct without intervention of the government. It is quote, "It is a promise of the Constitution that there is a realm of personal liberty which the government may not enter," from Casey. The Texas statute furthers no legitimate state interest which can justify its intrusion into the personal and private life of the individual. Had those who drew and ratified the Due Process Clause known the components of liberty in its manifold possibilities, they might have been more specific. They did not presume to have this insight. They knew times can blind us to certain truths, and later generations can see that laws once thought necessary and proper, in fact only serve to oppress. As the Constitution endures, persons in every generation can invoke its principles in their own search for greater freedom.
In the next excerpt from Justice Scalia's dissent, you'll hear a reference to the Bowers case that upheld the constitutionality of an anti-sodomy law, similar to the law declared unconstitutional in the Lawrence v. Texas case. Sonia will now read an excerpt from Justice Scalia's dissent.
The Texas law undoubtedly imposes constraints upon liberty. So do laws prohibiting prostitution, recreational use of heroin, and for that matter, working more than 60 hours per week in a bakery. But there is no right to liberty under the Due Process Clause. We have held repeatedly that only fundamental rights qualify for this heightened scrutiny protection. Bowers held that criminal prohibitions against homosexual sodomy are not subject to heightened scrutiny because they do not implicate a fundamental right. Homosexual sodomy is not a right deeply rooted in our nation's history and tradition. Today's opinion is a product of a court, which is the product of a law school culture that has largely signed onto the so-called homosexual agenda. Persuading one's fellow citizens is one thing, and imposing one's view in absence of democratic majority will, Persuading one's fellow citizens is one thing, and imposing one's views in absence of democratic majority will is something else. I would no more require a state to criminalize homosexual acts than I would forbid it to do so. It is the premise of our system that those judgments are to be made by the people, not imposed by a governing caste that knows best.
When Justice Kennedy said that as the Constitution endures, persons in every generation can invoke its principles in their own search for greater freedom, he was making a statement in the tradition of the constitutional interpretation known as the living Constitution. This approach is strongly opposed by Justice Scalia and his allies, but it was eloquently advocated by Justice Brennan in a talk he gave in 1983. Patrick will read an excerpt from Brennan's talk.
We current justices read the Constitution in the only way that we can, as 20th century Americans. We look to the history of the time of the framing and to the intervening history of interpretation. But the ultimate question must be, what do the words of the text mean in our time? For the genius of the Constitution rests not in any static meaning it might have had in a world that is dead and gone, but in the adaptability of its great principles to cope with current problems and current needs. What the constitutional fundamentals meant to the wisdom of other times cannot be their measure to the vision of our time.
Justice Scalia and the other dissenters in these cases represent a challenge to Brennan's position in the name of originalism and respect for majority will. While I'm at it, I should say that many observers have argued that these conservative justices have contradicted these principles of original meaning and respect for majority will in the Citizens United case, the gun control cases, and in many of the questions posed in the oral arguments before the Supreme Court on the healthcare law. But returning to the liberty-privacy cases, most of the students and I agree with the majorities in the contraception, abortion, and gay rights cases. Still, putting these cases in the context of the Lochner case, which involved a broader interpretation of the Constitution to strike down a liberal law, requires the students who agree with the liberal interpretations in the liberty-privacy cases to confront significant challenges that force them to complicate their thinking and become more sophisticated advocates of their opinions. We'll now turn to the second component of the course, the mock trial competition, in which students play the roles of lawyers and witnesses in a hypothetical case prepared by the New York State Bar Association. Each school presents both sides of the case on different days in competition with other schools. Judges, who are often assistant district attorneys or lawyers in private practice, award points based on the quality of each lawyer's and witness's performance and determine a winning school for each round. This year's case is a criminal case involving an assault at a hip-hop club. The students will present a direct and cross-examination of the defendant in the case. I'm going to yield the podium, and the defense will call the first witness. Okay, do you want to come up here? Nice. And the first witness has already arrived. Take her seat.
The defense calls its first witness P.J. Long. Could you introduce yourself to the court?
My name is P.J. Long.
Where do you live?
I live at 534 Dodge Street in Kew Gardens, New York.
And where do you work?
Well, I used to work at a machine shop until about 2 months ago. Now I receive unemployment.
Where were you the night of March 18th, 2011?
I was at the Joint. It's a local hangout with a couple of friends.
Was Dana Malone there?
Yes, she was.
Did you talk to her at any point that night?
Well, I was sitting at a table with my friends, and then she bumped into me and caused me to spill the majority of my drink.
Did she apologize?
No, she did not. Instead, she shouted, "Watch it."
Did she offer to buy you another drink?
Nope.
And how did you react to this?
I mean, I was a little upset. She spilled my drink. I was having a nice time. But, you know, I don't like to get into people's faces, so I just let it go.
Then what did you do?
I hung out for a little while longer.
Do you remember when you left?
I think I left a little before 9, but I really don't know the exact time.
Okay, PJ, let's talk about Shannon Taylor. Was Shannon Taylor at the Joint on the March 18th, the same night Dana sustained her injuries?
I think I saw Shannon there.
And what does Shannon do?
Shannon used to work at Pizza Galore until he was fired because somebody accused him from stealing from his employer.
Do Shannon Taylor and Dana know each other?
Yes, and they do not get along.
Did he ever threaten to hurt Dana?
Well, about two months ago, or in January or February, he told me that if he ever catches Dana alone at night, he's going to put a dent in her skull.
Objection, hearsay.
Your Honor, we are not using this statement to prove Shannon Taylor's character. This is an exception to the hearsay rule. Rule 403 states that a judge may admit an out-of-court statement of the declarant's then existing state of mind, emotion, sensation, or physical conditions, such as intent, plan, or motive. Such out-of-court statements of pain or intent do not present the usual concerns with reliability of hearsay testimony. We're using this statement to that PJ just said to show motive, intent, and plan that another person who was not investigated or questioned by the arresting officer had to physically harm Dana in the same way Dana was harmed.
Ms. Church, yes.
This is an incredibly self-serving piece of hearsay that is coming from the defendant herself. If it was an unbiased source, but I believe that it would be unfair to admit it, since it is the opposite of against personal interest.
May I respond? However, it is such a huge display of intent, plan, and motive that was not investigated by the police. We have to, it's not fair not to include it for the defendant's sake.
Okay, do you have any other witnesses who are going to confirm this statement?
No, I do not.
Okay, I think we're going to rule it out, so we'll sustain the objection.
Okay. So, now PJ, let's go back to the night of March 18th. What were you wearing?
I was wearing my favorite jacket.
Does anyone else you know have this jacket?
It's an incredibly popular jacket, but I have it, and I know Shannon Taylor has it.
Your Honor, may I approach the bench?
Yes.
I'd like to use Prosecution Exhibit 2.
Okay.
May I show a copy?
Yep.
Okay. PJ, what is this?
This is an ad for the jacket I own.
And can you describe the ad on the jacket for the court?
It's a unisex black leather motorcycle jacket with a big white eagle on the back.
Is this the jacket you were wearing?
Yes, it is.
So once you left the joint that night, what did you do?
I drove home and I waited for my roommate Sal to get home until about 10:30, and then I just listened to music in the meantime.
What type of music do you like?
I like rap music.
Who's your favorite artist?
My favorite artist has to be DJ Cold Blooded. He's really popular right now, and he just won a Grammy.
Were you listening to him that night?
Of course, I listen to him all the time.
Okay. Now, PJ, how did you get to and from the joint on March 18th?
I drove my car.
Can you describe your car?
I bought it about 3 years ago. It's probably about 20 years old. It's a little bit of a piece of junk, but it's close to my heart.
Do you keep things in the trunk?
I don't like to. The trunk is never locked, and I'm always sort of afraid someone's going to take something.
Do you keep a tire iron in your trunk?
When I bought it, I never checked, but I can't really say if I ever have owned one or not.
Okay, who charged you with the assault against Dana Malone?
Officer Callahan.
Did you know Officer Callahan before she arrested you?
Objection, relevancy.
As stated in our opening, the defense believes that Officer Callahan narrowed in too quickly and unfairly on PJ as a suspect without investigating any other suspects because she has a previous negative history with PJ. In Officer Callahan's cross, she admitted to disliking PJ due to a previous incident. We want to expand on this incident.
Okay, we'll overrule the objection. Go ahead.
Okay. So I will repeat the question. Did you know Officer Callahan before she arrested you?
Yes, in 2009, Officer Callahan arrested me for a crime I did not commit, just like she arrested me for this crime I did not commit.
Can you tell the court about that previous encounter?
Yes, in 2009, she falsely accused me of shoplifting, and then when I tried to explain to her that I had not shoplifted and that there had been a mistake, she took it as resistance.
How did she respond?
She tased me.
Did you do anything to provoke Officer Callahan to tase you?
I really was just trying to explain to her that there had been some sort of mistake.
So what happened with the shoplifting charge?
The charges were dropped.
Did you let anyone know that Officer Callahan had tased you?
Well, after the charges had been dropped, I filed a complaint with the Internal Affairs from the police department, and then somebody came to interview me.
Okay, finally, PJ, please tell me, did you assault Dana Malone in the parking lot of the joint on March 18, 2011?
No, I did not.
Nothing further, Your Honor.
Okay. Cross-examination?
Yes. Okay. So PJ, you and Dana had an altercation on the night of her attack, right?
Dana bumped into me, yes.
And she spilled your $5 drink, correct?
She spilled my drink.
And you weren't very happy about that, were you?
Who would be?
But you considered getting into her face for it, didn't you?
I don't like to cause trouble. Max doesn't like trouble, so I didn't get into her face.
But you actually said that you didn't cause trouble only because you didn't want to be thrown out of the joint, right?
Well, I don't like to cause trouble. I wouldn't want to get thrown out of the joint anyway, so I just stayed out of it.
But you and Dana are not friends, right?
She doesn't have too many.
And in fact, you yourself don't really like Dana, do you?
We don't get along. We're not the best of friends.
And you would even go as far to say that the way she carries herself makes you sick, doesn't it?
A couple people would agree with me on that one.
But yes or no?
Yes.
And PJ, my client had to go to the hospital for the injuries that she sustained, 15 stitches, yet you believe that she deserved the attack that she got that night at the joint, don't you?
You know, when I wrote my affidavit, I was a little upset. And so at the time, yes, I did believe she deserved it, but now thinking back on it, no one deserves to be injured in that way.
Do you remember when you wrote your affidavit?
December.
Which was more than 9 months after her attack, correct?
I hold a long grudge.
I want to talk about the lack of a tire iron in your car. You can't say whether or not you had a tire iron in your trunk, can you?
I've never needed one.
Yet you've had this car for nearly 3 years now, right?
Yep.
And you describe it as a piece of junk that's nearly 20 years old.
Mm-hmm.
And yet you still claim that you've never had the need to check for a tire iron.
Well, I never have.
And isn't it true that there was no tire iron in the car when Officer Callahan searched it in March?
Objection, speculation. She doesn't know what was in the trunk when Officer Callahan
I'm just asking her if she knows it. I think that it's a very logical connection to the case.
Well, I don't think I ever had one, so I assume that he didn't find one.
Okay. And PJ, when you got home that night, you listened to music, didn't you?
Yes, I did.
Specifically, you were listening to the song "The Sucker Gotta Die," weren't you?
It's from my favorite artist.
And you were actually listening to it over and over again about 3 or 4 times, correct?
Most people like to listen to their favorite song on repeat.
Okay. And you cannot testify surely to where you were at 9 p.m. that night, can you?
I was driving home around that time.
But no one else can testify to where you were either, can they?
Well, I was alone in my piece of junk, so.
No further questioning.
Any redirect?
No.
Okay. Just to explain it, just to explain, the witnesses are bound by their affidavits, so that's why she was stuck with some unfortunate statements that Susie was catching her up on. As you've just seen, the students have learned a lot about legal advocacy and the rules of courtroom procedure. But more importantly, they've learned how to analyze a case, focus on the main elements, and think on their feet. These are skills that will serve them well no matter what their future career. It's a pleasure to work with the students in this course and to see them grow in their thinking, their writing, and their self-confidence. So I think we have some time for questions if people have questions. Yeah.
Has your view of the Constitution changed since you was on the course 30 years ago?
Well, that's a good question. I understand it in more depth, and I think I bring a little more complexity to it, but I think my opinions on the cases are probably similar. Yeah?
Can I ask a question of the students? I was just curious about what you found most surprising after taking the course. What didn't you expect you would think about or learn that happened?
Anybody can answer the question.
I mean, I found that I expected to have a very specific opinion on the Constitution, more towards the living Constitution perspective of it, but then we actually did these mock debates where we would be the justices and 2 of our students would perform as lawyers. And I think we came out with some pretty surprising decisions that we realized that it was a lot more difficult to decide to interpret the Constitution so idealistically and loosely, I guess, not idealistically, but very, it was much harder to interpret it than just to stick to exactly what it said, and I think that all surprised us based on that.
Pretty big achievement.
Other questions?
Thank you.
Yeah.
Is it true, Charlie, that the current activist court is different from the old conservative courts because they're not strict constructionists anymore?
Well, it's complicated because they claim to be strict constructionists, but as I said on those three kinds of cases, they're not, and they are really quite activist. I guess we'll see what happens in the healthcare case. I thought someone would ask me about that, so I had my answer ready, which is my two gurus are Jeff Toobin and Linda Greenhouse, and some of you probably are familiar. Toobin is very pessimistic about which way the court is going to go. He thinks the court will strike it down. And Linda Greenhouse is cautiously optimistic. So
there you are.
So there I am. So I'll just vacillate.
Can I ask a follow-up, Charlie?
Yeah.
Do you agree with people who think that if the court keeps pursuing this extreme activist line, they're going to get discredited?
Yeah. I mean, I think if they're going to strike down the healthcare law, there's going to be quite an uproar.
That's a number in a row they've done.
Yeah. I mean, again, the gun control laws have a long history. The campaign finance laws have a long history. So they've gone against a lot of precedents. And this is really, if they strike this down, it is sort of a return to the New Deal court. And it comes in the wake of Bush v. Gore. So not all of the ones on the court, not all the people on the court now were there for Bush v. Gore, but still, in terms of conservative activism, it's there. Yeah.
What do you think about President Obama signing of the National Defense Authorization Act, which effectively, to many of us, suspends habeas corpus? Do you think it'll stand?
Oh yeah, with this court. Yeah.
Of course, I'm sure it will.
I think he's been frustrating to people who have a stronger civil liberties point of view, but I think it's clear he's trying to balance things out politically. And yeah, this court would certainly sustain him.
I had a thought. Do you think it has anything to do with him having taught law at Chicago, which is pretty conservative?
I think it's more, I mean, my guess is it's more political. My guess is it's more political. Ben, I'm sorry, Ben? Go ahead.
I'm just curious about the mock trials. Have they changed over the years that you've done them in terms of the scope or the focus of the trials?
Yes, they did. That's sort of a setup question. I've told the students this. Yeah. For years, the mock trials were written by a couple of lawyers from the New York City Bar Association. And we got a lot of really interesting cases that students could really learn a lot about a subject while they were working on the case. So we had gender discrimination cases, we had sexual harassment cases, we had disability rights cases, environmental cases. There were real points to the case, and the kids really learned a lot. Then it was writing the cases was taken over by people from the New York State Bar Association, and we had case after case after case about teenagers driving cars, which of course was not the world of New York City students. And year after year, the New York City teachers complained about the cases. One exception was, to give you a sense of well, you'll see. One exception was we got a case that was based on the sort of Bernie Madoff scandal, a version of that. And when the person who was in charge of preparing the case came to the New York City teachers, one of the teachers raised their hand and said, I can't understand this stuff. How am I going to explain it to my students? Because there was complicated maneuvering that was hard to figure out. And the response was, well, surely you have some parents who are lawyers, accountants, financiers. And the teacher said, no, I teach in regular New York City public schools. I don't have parents like that. And it was sort of a sign of the real insensitivity of what was happening. So this year's case, after all the complaints from the New York City teachers, is what I call the suburban nightmare of life in New York City.
But it still involves driving.
What?
It still involves driving.
Yes, it does involve driving, but the other cases all involved accidents. So this involves an assault at a hip hop club with a tire iron, by a defendant who listens to this violent rap song where someone gets killed by someone using a tire iron.
Oh.
So, and almost every witness is in trouble with the law in one way or another. So as I said, it is like a sort of suburban nightmare vision of life in New York. But we're doing the best with it that we can.
A suburban kid would have known about the tire iron.
That's right, no to check the tire iron. But she's just from Kew Gardens, Queens, as it's called in this case. So she didn't know.
Just seems to me also that one of the things that comes up from all of these cases and the cases in the news as well is that the American mythology is always about the strict separation of functions and the objectivity of function, and it leaves out issues of power and politics. And what we really see in the cases you discussed here and in things like Citizens United, etc., is that the law is not divorced from politics, and the selection of justices is all political. The Republicans have been picking 23-year-olds to sit on the Supreme Court to be able to control
Decisions
the law for years.
Yeah. I mean, as I said earlier, I think studying the Supreme Court is really interesting because it does involve politics, history, biography, and ethics and values. And so it really is an interesting mix of things. And I think the students see that justices are very influenced by their own histories, their own values, their own political ideas, but they're also working within structures that force them to try to rationalize and explain in ways that are convincing to other people who don't necessarily share their views, so that the views gain legitimacy. And sometimes they do that well, and sometimes not so well, and sometimes the cases appear more political, and sometimes they appear more solidly grounded, and that's part of the struggle.
You also get the politics within the court itself. You point out that that core of 3 people that maintained Roe was a Republican-appointed,
yes,
albeit presumably moderate liberal Republican-appointed court that went to stare decisis instead of changing the law.
Yeah.
So with the politics of the court itself, O'Connor specifically, you kept that centrist role.
Yeah, so 2 of them were appointed by Reagan and 1 by George Bush the First. And Jeff Toobin says that Souter walked down the hall to seek out Sandra Day O'Connor and say, I don't like the way this case is going, let's see what we can do here. And O'Connor herself was the champion of the undue burden standard, a standard that, the undue burden standard, again, it's her limitation on when states cannot restrict abortion rights. So what they did was say that they were upholding the core of Roe, but they were going to allow states to pass new restrictions that wouldn't have been allowed under Roe as long as they didn't create a, quote, undue burden. Obviously a vague standard.
And I think she may be one of the last members of the court that was actually a sitting legislator before she went on the court.
Yes.
And that fits into some of the dynamic as well.
Yeah. Clinton floated the idea of appointing someone with a political background, but that didn't work out. Now all the justices on the court are from appellate courts and don't have the kind of political experience that obviously someone like Earl Warren had. He came completely out of a political career and was able to pull a majority of the court together in the Brown case. And O'Connor very much, we talked about this a lot in class, O'Connor very much looked for decisions that the public could support. So she looked for a compromise on abortion, she looked for a compromise on affirmative action. And critics argued that she was too politically flexible and didn't have firm ideological standards, but her defense is that she was seeking a position that the public could settle on and be comfortable with on these important issues. Yeah, Greg?
Do you have
I'm sorry, go ahead.
Yeah, you have any sense over these last 30 years and how many people who've taken the course have gone on and become lawyers? Is it a higher percentage than normal? Or?
I don't know. Well, But what the lawyers who work with me and I say to the students, and I said this at the end, is that whether they are interested in becoming lawyers or not, I think these are really great skills to learn, to read carefully, to argue well and precisely and thoughtfully, to look at a complicated case and pick out main points, and as you saw, to be able to think on your feet and argue intelligently in a focused way. Greg?
Are there any experiences of teaching this course that really stand out to you?
Well, I have one funny story that I'll tell, which I thought was really great, which is many, many years ago, we got quite far along in the competition. Maybe we were in the Final Four, and in New York City. Then, if you win New York City, you get the reward of going to Albany, and continuing to do the case many, many, many more times. And it was a very close case, and it was a very close competition against another school. And usually at the end of the cases, the judges explain who did well and what you did well, what you could have done better, that kind of thing. So at the end of the case, the judge starts off and says to our lawyer who did a key cross-examination in the closing, "You would have been really great on any day, but you ran into a real meat grinder. This guy, the other guy, was out for blood, and he just used one violent image after another." And then he announced that we had lost by half a point. And then he came over, so I gathered the group together and said, you know, we really got very far with this. You're probably all sick of the case anyway, because you go over the same case over and over. You did really well. You should be really proud. So he came over and said, well, I'm sorry you lost by half a point. And one of the kids said this priceless comment. She said, oh, that's okay. We're Quakers. We don't believe in competition. I don't think the possibility of not believing in competition had ever crossed his mind. Yeah, Emily.
So I'll make the assumption that probably at Friends Seminary, like the majority of students enter kind of already on the liberal end of things and, you know, thinking of it as the living constitution. So I'm curious about when you have students who are, I'm assuming in a minority as more conservative students, how does that play out in the class and how do you manage it as a teacher?
Well, I think one of the nice things about the course is that the students get a well-argued position by somebody who is very conservative. I mean, it could be Scalia, it could be Rehnquist, so that they have something legitimate to work against or work with. And even if the majority of, and I've had students who sort of stood against the majority on these kinds of cases, but they have something to back them up. They have something to legitimize them. They have something to help them clarify their argument on that side of the case. On the other hand, they also have to come up against the arguments on the other side. So I think it's a good experience for them. And yeah, I've had several students who are quite politically conservative who've felt good about the course and felt good about studying it this way. Yeah.
Can I bring you back to healthcare?
Yeah, okay.
Since you were expecting a question. But I read somewhere that one of the key cases involves a farmer.
Oh, yes, yeah.
And you know what I'm talking about. That's
yeah.
good.
I don't know that case well, but I do know what it's about.
Where I guess it was a law passed by Congress ordering him not to grow.
It placed limits, yeah. I mean, the basic farm agricultural laws, bizarre as they are, set production limits on farmers, and then they get subsidies, and that way they prevent overproduction, which they saw as causing the drop in farm prices during during the 20s, but especially during the Great Depression. And the case, it's sort of a bizarre, I should say as an aside, it's a bizarre way to handle a problem of, quote, overproduction, which is really a problem of underconsumption. There are people who need the food, but anyway, that's the way the government handles it. So the case involves someone who grew wheat, I think it was wheat, for his own consumption, to feed his animals and to use however he was going to use it within his farm. And so his argument was that he shouldn't be bound by this law because he's not really engaged in interstate commerce. Congress's power to regulate broad economic matters is based on the power that Congress is given to regulate interstate commerce. And so he claimed he wasn't in interstate commerce. But the court ruled that by producing for himself, he wasn't beyond what his restriction was. He wasn't buying someone else's wheat that he would have had to purchase, and therefore he was impacting interstate commerce, and therefore the law was constitutional. So the argument here is, of course, the analogy would then be, by not buying health insurance, you're passing the cost along to somebody else, so you are affecting a broad interstate market. We'll see whether
that argument in that particular case.
Yeah.
And Scalia, I believe, he voted with the majority of that.
No, that case goes back much earlier.
Okay.
It's much earlier.
New Deal?
Yeah, it's a late New Deal case. But I should probably wrap up pretty soon, but I read a letter in the Times by a lawyer who just pointed out that the current court's decisions seem to suggest that the right of people not to be strip searched without some reason on the part of the correctional authorities or the police doesn't seem to be that important a right, but the right of people to pass the cost of their health care on to somebody else by not buying health insurance and expecting other people to pick up the bill when they go to emergency rooms seems to be, for at least some of them, a very fundamental right. So it's kind of a strange view of what the fundamental rights are. You can see from what the cases I've been talking about, the issue is often, is this really a fundamental right that in some way is parallel to the rights explicitly stated in the Bill of Rights, which most justices would say need the Supreme Court's protection. So in this case, you get these two competing rights, the right to pass healthcare costs on to someone else versus the right not to be strip searched because you may or may not have paid a fine in the past. Yeah, Bob?
I just wonder, if you look at this problem of lifelong appointments and the fact that, you know, this came about when people lived till 50 years old, now they're 90. Is there any way to change that? Are there solutions that you've looked at or other?
I don't. There was a suggestion in the Times op-ed piece that there should presidents should get an appointment every 2 years. Roosevelt, of course, tried to pack the court, and Congress rejected it. He argued that because they were the 9 old men, I have more sympathy for them now. Everyone over 70 should, for every justice over 70, he should get the chance to appoint another justice up to a maximum of 15, and Congress rejected that. So that was an attempt to change it. It's hard to see what kind of a system it could change to that would be fair. I mean, the theory of lifetime appointments, but you're right, people's lives are much longer, of course, but the theory of lifetime appointments was that the justices would be politically independent. They wouldn't have to worry about getting renominated or reelected or whatever, reappointed. But there has been, as was mentioned, a move to appoint younger and younger justices so that they have an enormously long impact. And I don't know. We'll see. I think this case is going to. I think the healthcare case is going to be very important. And I think if the court strikes it down, there's going to be a lot more talk about those kinds of issues.
Who was the youngest justice next year?
What?
Who was the youngest justice ever appointed?
I'm not sure.
Marshall. Marshall was very young when he was appointed. First justice.
John Marshall? Yeah, that might be true. I'm not really sure. What?
I think.
Oh, okay, just last question.
Is there anything that in the founder's writings that supports the statement by Brennan that was read? Basically that you interpret the Constitution not as it's originally written, as if it's inviolate, but that it needs to be attuned to the times that you've done it.
The people who argue that, and the Kennedy quote that was read before in the by Susie make the argument that if the founders had wanted the rights to be more clearly specified, they would have done it, and that by using broad sweeping language of the kind they did, they assumed that there would be an evolution. And that's the main argument for that. The other thing is the Ninth Amendment, which does say, although people argue about how that can be interpreted or how it can be used, that essentially it says the enumeration in the Constitution of certain rights shall not be construed to deny or disparage other rights that the people still retain. That was used more, actually in the Griswold case. Some justices wanted to rest the case on that, but it really is a kind of blank check in a way for the court. So more of them were emphasizing that it encourages a broader interpretation or a looser construction rather than resting it exactly on that.
But it's also true that the language of the Constitution and Bill of Rights were itself political compromises. So the language they come up with was intentionally vague to get enough votes.
Yeah.
So it's kind of an oxymoron to say that it was set in stone.
Yeah, I mean, again, one of the problems for the originalists is how do you figure out what they meant originally, since so many people played a role.
None of them wrote specifically on that topic that you know of?
Well, I don't think there's anything that really clearly settles it. Okay, I think I should probably end. Thank you very much for coming. Thank you.